nine petitions to modify that you say I didn't file. You know what I mean? Like, what else am I supposed to do? I can't afford a lawyer. I don't have the money to fight this in a family court, right? And I was coerced into this system, right? And she's 20 years older than me. She knew exactly what she was doing, right? And
And the state would like to ask the court to note that as this is a non-agreed CSRP, there previously was a wage investigation done in this case.
Court
So
will take judicial notice of the court file and information contained in the not agreed to child support review order, petition and request. Thank you.
thank you, Judge. The state is of the understanding that the parties are in agreement that the medical support going into the future will be provided by the non-custodial parent, Mr. Werner, at $99.62 per month. They are likewise in agreement that the dental support going into the future will be provided by the non-custodial parent, Mr. Werner, costing $16.28 per month. Likewise, as to the question of arrears, the parties are both in agreement that $9,970.29 of said arrears be released. Particularly the non-custodial parent is in disagreement regarding the following: that his gross income is $6,991.33, with four children outside of the order, causing a guideline child support to fall at $748 per month. And he's in a disagreement that the total arrearages following that release of almost 10 grand in arrears come to $20,000 in a child support arrearages, set with the repayment $150, and likewise a medical arrearage of $1,755.40, with the repayment at $59 per month.
Okay, let me look at the package. Thank you.
Thank you, Judge.
All right, I'm sorry, we were still on pause. And again, I got the information. So we're looking at the agreed part being the credit and the amounts of cash, medical, and dental. The disagreements being the arrearage still owed based on the information plus the guideline child support. And again, let me see what I've been filed with this. All right, at this time, I'll go ahead and ask both parties to unmute themselves. Ms. Werner's up and running. I need Mr. Werner. Is he still here?
I am looking, and I think he might have dropped. Allow me to.
Okay, did he end up back in the breakout room?
Yes, for some reason. Let me go grab him.
Yeah, that happens. Way too much for some strange reason.
Now should be back in the main room.
All right, Mr. Werner, you there, sir?
yes, sir, we're here.
Okay, did you hear the states? You kind I didn't see that you were gone out of the room. Did you hear the states summation of what the agreements and the contest are in this matter? Otherwise, I'll go ahead and have him do them again. Did you hear those, sir?
No, I didn't hear what you were saying. I apologize.
All right, Mr. Go ahead one more time, then. Thank you.
Okay, so it's the state's understanding that both parties are in agreement that the medical support going into the future be provided by the non-custodial parent, that is Mr. Warner, at a cost of $99.62 per month. Dental support likewise to be provided by Mr. Warner at a cost of $16.28 a month. And they also agree as to a release in child support arrears to the amount of $9,970.29. The parties are not in agreement as to the Mr. Warner's gross income being $6,991.33, with four children outside of this order, bringing the guideline child support current amount to being $748 per month. Likewise, the state understands that the parties are not in agreement that after that release of arrearages, the total of child support arrearages would come out to $20,000, with a repayment of $150 per month. as well as an additional medical support arrearage of $1,755.40 with a repayment of $59 per month.
All right, go ahead. Anything else, sir?
No, no, Judge. That's the entirety of this.
All right, then, Mr. Warner, you hear all that?
Yes, sir. I heard it that time.
All right, good enough then. Anyway, sir, I'm getting ready to go ahead and swear you and Miss Werner in, and we're gonna get some testimony, and we'll try to figure this one out without everybody having to come downtown and bring paperwork. But this time, the state says you are not in agreement with they show as your gross income each month, sir. So I'll let the state's going to ask you questions specifically where you work, what you what you have, and then whether or not you've gotten any proof right here today of what you earned. And I usually look at the W-2s and income tax returns and that sort of thing to show what income is. Because bottom line, if you don't tell the IRS, you may get away without telling me too. So there you go. But anyway, I'll go ahead and let the state call you both as witnesses. And at this time, and I'll let y'all both testify this information. But I do need for you to unmute yourself, sir. And I mean, sir, turn on your video and raise your right hand along with Ms. Werner. Thank you. Is your video working, sir? Yeah, and you're muted, Mr. Werner. You need to unmute yourself also.
Oh, I'm muted. I apologize. What was I supposed to be saying something?
Yeah, I need to swear you in as a witness, sir. I need for
Oh,
you.
okay. Yes, sir.
All right, you need to turn on your video, please, also. All right, yes, sir. All right. Raise your right hands, please. You both solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you.
Yes.
All right. And sir, if you're going to, you both put your hands down. If you got your own cellular device, for the likely to find a spot, and that way we won't lose a signal because you're moving around. And I'll go ahead and let the state call you both as individual witnesses. You may proceed at this time,
Right.
Mr. Green. Thank you.
Thank you, Judge.
And you can,
State would like
drop
to
your
call
videos.
Carrie Berner.
All right. Ms. Werner, would you state your full name for the record, ma'am?
Oh, Carrie Salcido Warner. Oh, real quick, I got remarried. So do I go with Warner in this situation?
Go ahead and tell you what your legal name is at this point, ma'am. But we're going to refer to Mr. Werner because of the case. Yes, ma'am. But what's your legal name?
Okay, it's Carrie Salcido Weideman.
Okay, thank you, Ms. Weideman. You may proceed at this time with the witness, Ms. Gwen. Ms. Gwen.
All right. Carrie, what's the name of the child we're here on today?
Elena Rachel Warner.
Okay, and what's her date of birth?
3/18/09.
Okay, so that would make her about 16 if my math is correct, correct?
New 16, yes.
Okay, gotcha. So you heard what I stated that you and Mr. Werner are in agreement with, correct?
Correct.
And would that reflect the agreement as you understand it, where y'all agree that is?
I'm sorry, repeat that.
Is that something that you agree to, what I stated?
I agree.
Okay. And you also heard that I stated that there was there was a previous child support arrearage of $29,970.29 arrearage. And since you've agreed to that $9,970.29 release of arrearage, that would bring that total to $20,000 in child support arrearage. You're in agreement with that?
That is correct.
And that would have a repayment based on the state's math of $150 per month. That would be acceptable to you, correct?
Yes.
Okay. And you understand that the medical support arrearages was at $1,755.40, correct?
Correct.
And the state's repayment was set at $59 per month. Is that an acceptable number to you?
You broke out that last part. I'm sorry.
I apologize. There's some bad weather in my area.
Yes.
That would be set at a repayment of $59 per month. That's acceptable to you?
Correct. Yes.
And you understand, based on the income determination of Mr. Werner, to be around $6,991.33, with 4 other children that he cares for, the child support would be calculated for current child support going forward at $748 per month. Are you of that understanding?
You cut out at the amount.
Okay, $748 per month going forward in child support. Did you hear me that
I have
time?
no idea. Yes, I have no idea what he makes, and but
Okay, but
that's
if that was
is that the number? If that's the numbers, then that's the numbers. That as far as the math of what I know about it.
Is it,
I am not aware
that
how
was
much
one
he
of my
makes.
questions.
Mr. Werner, you're not the witness now, sir. I'm sorry. Mr. Werner's the witness. This is just, we're doing this on Zoom, but it's still a court law. Court law is just like she's on the witness stand right now, and you'll get to ask your questions when it's your turn to speak, sir. Thank you. You may proceed at this time,
And
Mr. Mann.
do you have any reason, Carrie, that you would not want to go by guideline child support?
No, I
Okay,
do not.
I have no further questions for this witness, Judge.
All right, Mr. Werner, I'm going to go ahead and let the state call you as a witness, and at the end of the questioning, sir, you'll get to ask questions as needed, sir. But for right now, you just need to listen to the question and answer the question that's asked. So I'm going to go ahead and let the state call you as a witness, and you may proceed.
State would like to call Mr. Michael Werner.
All right, sir, state your full name for the record, please, sir.
Michael Werner.
All right, thank you. You
All
may
right.
proceed.
Mr. Werner, did you hear what the state purported to be the agreed elements to this case before the court?
Yeah, like I stated before, the numbers, I hear the numbers, but I do not agree.
But as far as providing medical support and dental support, as well as that $9,970.29 for release and child support arrears, you do agree with those numbers, right?
I mean, yeah, I've been providing insurance for a couple years now, and
Okay,
I
and that
do
is
feel
$99.62 per month for medical insurance and $16.28 per month, 28
yeah,
cents per month for dental support. That is correct, right?
yes,
So as the state had previously told this court, you are in agreement as to those numbers, correct?
yes.
Okay, thank you. Now, as far as the arrearage amount, you've heard the state list testimony that the total child support arrearages as of the 31st day of March of this year had been $29,970.29. So after the $9,970.29 release, that would leave you with a child support arrearage of $20,000. Is that your understanding?
I mean, that is the numbers, like I said, but I don't
Okay.
agree with
And
that number.
I'll ask you a question about that in a second. And you understand that the state, based on that number, is requesting a repayment of $150 a month so that you don't continue to accrue interest on that number? Or do you understand that's what the state is asking?
I understand that, yeah.
Okay, thank you. Now, you, however, disagree with that child support arrearage amount and the repayment amount. That's correct, right?
10-4, yes, sir.
Okay, and do you have any reasons why you disagree with that you would like to inform this court of?
Well, like we were talking, I mean, this all started in March of 2020, right? When the whole world was shut down and nobody was working and nobody had a job. And I called the child support offices to tell them, like, hey, the whole world is shut down. Nobody has a job, you know? And they were pretty much like, oh, well. and just continued to stack back child support, right? Like regardless of the fact that the whole world was shut down, right?
Okay,
And I
so
mean, I don't
so
understand how that could be
All
so
right,
Mr.
fair
Werner,
or legal.
I'll take that one. Here's the deal, sir. Unless you had lost your employment and filed the necessary
Which
paperwork,
I did, which
that,
I did. I followed all of those things.
here's the deal, sir. You did not come before this court or the district court to ask the court to suspend child support or to lower child
Oh well,
support.
I have
Transaction.
like nine denials of petitions on file right now, where I've requested for either a change in conservatorship or a motion to redo, and they've all been denied. Not and it's for I didn't pay $1.46. I didn't put a cover sheet on it, right? Like it's a whole bunch of ridiculous reasons, right? And I've tried my hardest to get in front of a judge, and it seems to I have to not pay child support for 4 years in order to get a visit with a judge,
Well,
right?
you got
And
one now, sir, and those things that you were talking about earlier, they're called the civil rules of procedure, and if you don't abide by them, that can you can get kicked out of court in a New York minute. But the bottom
well,
line is,
that's what I mean.
here's
And so they make
stop
it.
here, sir. Here's the deal, sir. I'm not going to argue with you, okay, Mr. Werner?
I'm not arguing. I'm just
Yes,
explaining my case. That's my right in the
sir.
courtroom, correct?
You're saying your reasoning, but the bottom line is do you have something to prove that that child support did not accrue during that time frame, as the state is alleging?
Well, I mean, I didn't even have a job. I don't understand that you could stack child support on me at whatever
You
number.
can,
Where did you come up
you
with the number?
can, you can, sir. Child support has already been ordered by the court, and that was still due and owing unless there was a counter order dismissing that or getting rid of that, sir. And there was not. I just looked at the file. That order is in full force and effect. So yes, sir, you owe that amount of child support, and there's no undoing
Even
it.
if I didn't have a job, even if I
Even if
reached
you
out to
didn't
the
have a
child
job,
support
sir.
office and I
Even if
reached out to the child support office and notified, right? So you're going to continue to stack money on me like if I have a job, even though you know that I don't have a job, and then you're going to put interest on top of that?
Mr. Werner, I'm getting ready to kick you out of this hearing, sir. I'm sorry, I'm
For
getting ready to.
what? Am
Mr.
I
Werner,
not
Mr.
allowed to
Werner,
ask a question, Your
Mr. Werner,
Honor?
here's the deal. I said this in my morning speech. I could put you in jail for acting out here on Zoom. I'm not going to argue with you, sir. This is like
Not
you standing
arguing.
right here in front of me, yelling at me, telling me what you're going to do and what I
I
should.
haven't even raised my voice, Your Honor. I
Okay,
haven't
here's the deal,
said
sir.
anything wrong.
Yes, Mr. Werner, you're not a lawyer. I am. And I'm telling you, you did not do this properly. Okay. I've got that money accrued the entire time, every month, the first of the month, just like always. And without a court order setting that aside by either the associate judge, myself, or the presiding district judge of the court that this matter was in. Unless you've got something along those lines, sir, it's there. And it cannot be undone.
And where's the law that says we have to partake in this system?
Well, yeah, you live in, it's just like the laws that say when you drive down I-35, if you go 100 miles an hour, guess what's going to
I know,
happen?
but there's a
Same thing.
law on the books with a number and a letter. Is it possible for me to see the law that says I have to partake in
No,
the
sir.
child
Here's
support
the deal,
system?
sir. I'm not going to quote you the Texas family code. That's up to you to either hire a lawyer or figure out for yourself, sir.
Well, I can't afford a lawyer because I pay a ridiculous amount of child support.
Well, those are the circumstances, sir.
And that seems fair to you as a judge?
Don't ask me what I see and think. Mr. Werner, I'm not, you see, again, we're getting into this little sparring match between yourself and myself.
I'm literally just asking questions.
No, well,
And I feel like that's my right.
Mr. Werner, I'm through answering questions, okay? Either you set for a point of law that the court can rule on, but right now, otherwise, we're not going to do this any longer. The court has
Okay.
accepted the information that you owe the child support, sir, and it's up to you to show legally why you don't. So what do you got?
I guess I have nothing then.
All right. Mr. Werner, you're still the state's witness. I'm going to let the state take you, and you're still on before the court as far as your testimony is concerned. But again, sir, you don't get credit because you don't have a job. You've got to come back in and ask the court to change things around, just like the state.
I did, and I got denied a petition to modify.
Well,
I don't understand what you would like me to do more other than that. I have several petition to modifies that I've been denied starting since 2023. right? I have them on file right here with the state, right? I've done my
Yeah,
diligence.
okay,
I
sir.
asked for a
What
petition to
part of
modify.
denied do you not get?
Well, why was it denied? You know, I mean, you sit there and laugh about it, but why was it denied? You
Okay,
know,
sir. I'm not, first off, it wasn't before me or the district judge that denied it. It was if you try to do something administratively and they denied that, then that's on the administrative process. But there's
I'm
nothing.
just saying that's my proof. You asked for proof, right? And I have several petitions for modification since 2023 on file with the state, right? What more proof can I offer than that?
Okay. Sir, can you see this file I'm holding up? This is what controls your
Can you
circumstance.
pull that up?
It has to be, you've had the file in this court file and this cause number at the district court of Bell County or district clerks of Bell County to do anything, any type of changes. If
Because
you
I
do
have
that,
case number 228121101 and envelope number 765333149. I have case number 281211101 and envelope number 765222428. I have case number 281211101 and envelope
okay,
number
Mr. Werner,
765062225 76470. You
Mr.
know, I have
Werner, stop. Where are those case numbers from? Are they from, because they're not in this file. This is Bell County cause number 281,211.
this is through the state. This is e-filed through the state.
Okay, here's the deal,
This is
sir.
at efiletexas.gov.
All right, sir. Anything else?
I no, sir. I don't have anything other than that. I mean, other than the 9 petitions to modify that you say I didn't file. You know what I mean? Like, what else am I supposed to do? I can't afford a lawyer. I don't have the money to fight this in a family court, right? And I was coerced into this system, right? And she's 20 years older than me. She knew exactly what she was doing, right? And I agreed to all of this stuff because I thought that I was doing the right thing. And I followed it diligently, right? And as soon as I had an issue, I've tried to bring it to y'all's attention. I've tried to do everything. And essentially, my only option is going to be to switch conservatorship, right? And then put her on child support, right? And I mean, if that's what it comes to at the end of this case, I've already filed that petition as well with the Bell County clerk, right? My daughter's old enough to choose where she wants to live, and that motion is already in
When
process
that
as well.
matter is brought before either myself or the district judge, we will take that matter up when it's brought before.
And then y'all will have this same energy though, correct? Like when we're in court, because like,
oh yeah, that's the way this is
okay.
going, Mr. Werner.
10-4, yes sir.
Okay. Any other questions, Mr. Gwynn? Still your witness.
I would finish asking that you are of the understanding that the state also shows that you owe a medical arrears of $1,755.40, correct?
Yes sir. And any way to defend that one either, even though I've had insurance.
And you understand that based on that number, the state's calculation comes out to $59 per month, so as you don't continue to accrue interest and that number merely grow. You understand that's what the state is requesting?
Understood, yes sir.
Okay. And you understand based on a income, a wage report that indicated you had $6,000, a monthly income of $6,000, $6,991.33, with 4 children that you are supporting outside of this order, with a guideline child support amount that would come out to $748 per month. Do you understand that's the state's math on that?
I mean, I don't know where you get the number from exactly, right? But I raised that question earlier. I'm not exactly sure how you could just impose that I make that much money and then tell me how much I have to pay, right? But
okay.
And when I asked, nobody could provide
Objection,
me where they got that number
non-responsive.
from.
Sustained.
You know?
Mr. Werner, only answer the questions that's asked, and the state will get from point A to point B once you let them, sir. Because the next questions out of their mouth are going to be, where do you work, what do you earn, and how, and so forth and so on. So just sit back and wait, sir. Thank you.
Yes, sir.
And let me somewhat start over there. You have 4 other children that you are supporting who are dependents currently still. Beneath the age of majority, they have not emancipated. Is that correct?
Yes, sir.
Okay, and you understand that when the state calculates its guideline child support, it includes those children in its equation. You understand that, right?
Yes.
Okay, thank you. Now, the state did a wage investigation and came up with a number of $6,991.33 per month. You understand that's a number the state came up with, correct?
Yeah, I do understand the state came up with that number, yes.
Okay. And you're disputing that number, it sounds like.
Well, I just would like to know where the number came from. I mean, you can't just
Objection,
tell me how
non-responsive.
much money I make. I'm
Okay,
stating my response. I'm not
okay,
being
so here's the deal,
unresponsive.
sir. Who do you work for?
I work at a plumbing company.
All right, here's the deal, sir. Your plumbing company sends in information every quarter on what you earn in the state of Texas that they pay for in your unemployment insurance. The state gets that data. Okay, this is what I know where they got it from. They hadn't, but now they're going to go over with you step by step. So you need to tell the absolute truth of what you earned and how much you earned, because again, they've got that data because your boss told them. All right, so let's rock.
Okay.
Let the state proceed and ask you the necessary questions, sir. And this is your chance to tell the court and under oath what you earned and what you're earning. And if they think there's enough, if you think there's a discrepancy, then the court will be more than happy to go ahead and make a temporary order, set this up for a hearing before the bench, and allow you to bring in your last 2 years worth of income tax returns and your most current pay stubs, and we'll figure it out. We'll rock and roll with those, sir. All right.
Okay, boy.
But I know where they got the data from, but they're not going to, that's just, the system's the system. They know what you earn, sir, if you work in the state of Texas. So I'll let the state proceed.
And the state would like to ask again, it sounds like you're disputing the state's estimation of your income, correct?
No, I'm not going to dispute any. I mean, I'm obviously not going to get anywhere. So, whatever.
All right, you still need to
Okay.
ask you still need to ask your income information questions, Mr. Gwen. Please proceed.
That's fine.
I'm
I'll answer
sorry,
whatever
Judge. I
question.
didn't hear you. It cut out for a
No,
second.
I'm not disputing. I'm not disputing.
Oh no, I'm not talking to you, Mr. Warner. I did not hear the
okay.
judge.
I said that Mr. Warner, he still has to ask questions about what you actually earn, and because that's the proof that the court needs one way or the other, and it's your opportunity to affirm or deny that information. You may proceed, Mr. Gwen.
Okay. And what do you currently do for a living, Mr. Warner?
I'm a plumber.
Okay, and that is full-time employment, correct?
Yeah.
Okay. State has no further questions this time.
All right, sir. Mr. Werner, what's your are you a salaried employee or an hourly employee?
I'm an hourly.
And what is your hourly rate, sir?
$35 an hour.
And do you average more than 40 hours a week at that job, sir?
No, I don't ever. I barely average 40 right at the moment.
All right. Historically, sir, do you normally work 40 hours a week at $35 an hour?
Yeah, sure.
Okay. All right. Any other questions of this witness, Mr. Gwynn?
I do not have any other questions of this witness at this time, Judge.
All right, then. All right, then. Mr. Werner, I will let you know that you gave a lot of information about the file numbers and everything that you filed, and obviously I think I'm not associated with the Attorney General's office. I don't know what their file numbers are or what they use for filing a request, but I will let you know I am in your court file, and the things that are in your file are the original petition for divorce in this matter, final decree of divorce from 2016. That was signed off on by the district judge ordering setting up custody, child support, and visitation. There was an order for modification in 2020 that updated that. And the only other pleading since then, the 2020 order or request to change child support or look at child support or update child support was the current one for the petition for confirmation of non-agreed to child support review order that was filed this year in this case, in this matter. Those are all the items that were requested of this court, either for the child support court or the district court that did your divorce. The items that you testified to, sir, sound like something you may have done administratively, but there were actually no requests to the court, and the court the courts are the one that actually make the orders and set up the child support orders. And you right now, there are two separate orders, a divorce order and a modification order for 2020 that controls at this point. So is there anything else, Mr. Werner, you wish to present?
It's just unfortunate that I don't get the opportunity to speak like I would like to, because y'all keep basically shutting me up, right? But I just think it's unfair, right, that I don't get any say in this matter, and you don't really look into the well-being of the child, and you really don't care about anything but the money, right? I just think that's super unfortunate, because this is not the way you run a child family system.
Okay, well, yes, sir, it is. This hearing is only about child support. There's nothing. There's nothing on this in this.
I know it's
asked me to look at.
Just unfortunate, Your Honor, because
Tate.
I've been trying so hard to get in front of a judge so that I could get conservatorship of my daughter, right? So that I can get out of this system, and I cannot seem to get in front of a judge. I keep getting denied through the attorney generals for modification. I understand that you're not attached to them and you don't have anything to do with them, right? And that's how they play the game, right? Is there's always a middleman, and I can't talk to you directly, right? And then all you care about is the numbers, right? So, I mean, it's just unfortunate. I just hope I get to have you as my lawyer, or my judge, as when I go for the conservatorship there in Bell County as well, right?
All right,
And
so
I just hope you remember this case.
Go to the proper court. The court will take those up. But for right now, sir, this is the only thing I've got. So, all right.
So enjoy it while you can, you know?
Yes, sir. Thank you. All right, then. Any other witness you wish to call at this time, Mr. Gwynn?
There's not, Judge.
Mr. Werner, the final thing I need to bring to your attention is that with the paperwork that was filed with your case, along with your waiver saying agreeing to be here today, was an investigative report that shows that the state's information based on the Texas Family Code 154.061, that your monthly net resources are $6,991.33.
That's my net resources?
That's your gross resources. I'm sorry. Your net resources based on that.
Oh.
That's what the net resources are based on the Family Code section 154.061. That's your gross. Your net resources based on the circumstances that take out your Medicaid, your Medicare, your Social Security, and your income tax brings you down to $5,501.33 a month. All right, and is there anything else at this time, Mr. Gwynn?
There is not, Judge.
And
I'm sorry. I'm sorry. May I ask you? So, the child support comes off of the 6,990, or does it come off of the 5,000?
It comes off the 5,501, sir, giving you credit for the other children that you're legally obligated to support.
So you only put 1,400 in for the other 4 children, and then 1,000 in for Carrie for one child who's 16?
No, sir. There's a percentage that is ordered against that income based on the number of children that are before the court today and the number of children that you're legally obligated to support.
I know, because my question is then, so if I'm supposed to pay 1,000 to Carrie, right, and this is the numbers and the codes, and it's going to go the same way in my other 4 child support cases, right? So I'm now being ordered to pay over $4,000 a month, right? And then how am I supposed to survive on that? I can't even pay a bill or anything. And does that mean that Carrie has no financial responsibility? Because that's essentially what you're telling us through the court when you give her housing and food stamps, and then you want me to pay $1,000 a month for the kid, even though I drive 16 hours every other weekend, even though I pay for her phone, even though I buy her school clothes, even though I take her on trips, right? Like, even though all of those things, even though she's been remarried, right? And they live with her friend, and the guy doesn't have anything, and she's
Okay,
only
sir,
pushing for child
you can get
support
to
so
your,
that he can have some money, right? Like, none of that matters, correct?
well, sir, if you're gonna put it like that, no, sir, it does not, because you're not paying
Exactly.
$1,000,
That's
sir,
unfortunate.
stop. You're not paying $1,000 a month in child support. You're paying $1,000 a month technically because of the unpaid child support amount that you did not pay for those all those years, and she was totally
The
responsible
unpaid child
for
support, the unpaid child support that I put in a motion for them to look at it and redo it, and they denied me several
Sir,
nine times,
here's the deal,
right?
sir. You have never put a motion before either this
To
court
you,
or
to
district
you,
court.
to you, exactly, right? To you, because I have to go through the middleman of the attorney general because you
No,
don't handle cases
no,
personally.
sir. Now here's the deal, sir. You could have hired a lawyer. You're
I
not.
can't hire a lawyer. I got to pay $4,000 a month in child support. How am I supposed to?
Well, here's the deal, sir. You've got to get it before the court, either through the state agency or your own legal
And
counsel.
this is my only shot, Your Honor. I'm in front of a judge right now. This is my only shot in 5 years, dude. And you're basically telling me that you don't care what I got to say and you don't care what's happened,
Mr.
and I'm
Werner,
gonna
you
have to
stop,
pay
Mr. Werner,
$1,000 a month.
Mr. Werner, stop trying to put words in my mouth and tell me what I'm trying to say. Understood? If you do it one more
Yes,
time, I'm going to hold you in contempt, and then you're going to do a couple of weekends in jail. Okay? Deal?
yeah, deal.
Okay. So here's the deal, sir. Don't put those words in my mouth. I'm telling you based on what I have in your order, in this motion, and the information. Those are your circumstances. That's what I've got to rule on. No, there's no way around that. You did not file with this court or the district court to modify. You tried to do it administratively. You didn't go out and hire a lawyer. It is what it is, sir.
Do you look at her finances or her
No, sir.
bills or her job, or
No,
does
sir.
it only
The
include
state
mine?
of Texas does not do that. Some states do that, but the state of Texas does not do that in the Texas Family Code. No, sir.
And it does not matter the amount of money that I have to pay, right? And how much I make per month. Y'all do not take any of that into consideration.
The guidelines are the guidelines. If you got something to show why the court should deviate from guideline child support, it's up to you to present that information, sir. And I know that's a lot of legal mumbo jumbo, but that's what it is. It's legal.
It's really what it is.
You've got to give
I
me a
can't do
legal
it.
reason to do something different, Mr. Werner, and so far you have not.
Yeah. That's what I mean. I would have to get a lawyer, right? That's the way the system works, right? For anything to happen. And I can't afford the lawyer. So I'm basically just stuck, right? Because that's what the law says. And you don't care how much money she makes, right? You don't care what goes on in the house. You don't care if she's in truancy court. And you don't care if it's really about the well-being of the child.
Mr. Werner. I don't want to put you
I'm
in jail.
asking. I
No,
don't want to
sir.
go to jail. I'm asking
And
questions.
I don't have to answer you, sir. I've answered you several times. I've told you what we're looking at, and I'm through. Okay.
All right.
Anything else, Mr. Gwynn?
Not at this time, Judge.
All right, Mr. Werner. I got to deal with the four corners of the file. I've got to confirm what the non-agreed to child support review order is, and the court is granting that at this time. You have the absolute right to de novo this to the district judge and let the district judge take another whack at it. But I guarantee you, sir, you're going to have to do that live, and you act like you did today in Zoom, there will be consequences. So if you're going to de novo this, yeah, that's an appeal, sir. That's the legal term for appeals from the 4D court. You have so many days to file a de novo. And I mean, it's a short time frame. You've got 3 days to de novo this to the district court. Three court dates. So that means you have to do this before this coming Friday. Otherwise, the district court will not be able to hear your de novo. You understand what I just told you, sir?
Yeah, I'm gonna go do it right now.
Okay, but again, sir, the district
Do I
court
need
is
an
going to
attorney
be
for that as
trained
well?
by what the law is, sir. So keep that in mind. You might want to go talk to a lawyer before you go down there. What's your final question? What's your next question, sir?
Oh no, I was just asking if I needed an attorney to do that as well, or are they gonna deny me? That's because I feel like that's why I keep getting denied.
No, sir, you have not ever filed anything with the court. You can if you can file a proper
I know.
If you can file a proper de novo with the district clerk's office, then it'll be taken to the district judge, but you got to figure out if you either got to get a lawyer to do it for you, or you got to figure out how to do it yourself, sir. And you could probably Google it and figure, and Google can help you figure it out.
Well, that's how I had tried it already, but it hasn't been working, obviously.
So, but anyway, sir, I'm gonna go ahead and have the state prepare that order. Once I've signed that order, sir, you got 3 days to file the de novo to have the district court hear it. But again, the district court's going to be limited to what's before the court based on the pleadings, and that's pretty much it.
I think I'm gonna wait. I think I'm gonna wait until after my conservatorship hearing, right? Carrie should be getting served with papers anytime pretty soon. I mean, I just took that stuff to the Bell County Courthouse, so or the county clerk's office.
But here's the deal, sir. Again, if you do not de novo, this is going to become a final order, and it's going to be carved in stone. You will owe that entire amount of money. You'll be ordered to pay child support in that amount going forward. You'll be ordered to pay everything else that's in that order will become final. So you've got 3 days to get that taken care of. Understood? I need you to understand that, sir.
Yes, sir.
All right, thank you. All right, then, Mr. Gwen, Miss Werner, any questions, ma'am?
A lot of information.
Yeah, it is. Yes, it is.
I guess my question is, if Mr. Warner is going to continue, like he said, with conservatorship and not in agreement, this still stands,
Yes, ma'am.
correct?
Unless he files the de novo
Within those.
to have the district court look at what was done here today.
Which is what I'm gonna do, right? So as long as it's in dispute, it does not stand, correct?
No, this order does not become final until it's until the district judge rules on it, sir, if you de novo it.
Okay, cool. Yeah, that's what I was getting at. And so I'm gonna do the de novo, right? And it will not stand until as long as it's in dispute. And so
No,
they should
sir.
not be calling my place of employment, right? Asking
Sir,
when I'm gonna make a payment.
Stop going off on tangents, and I will finish explaining this to you. The de novo
Yes,
will
sir.
usually take place, and your hearing will usually take place sometime within the next 10 to 14 days at the district court level. The attorney general will appear, the mother can appear, and you need to appear. And at that time, if the district court goes ahead and affirms what the court did here today, that will become the final order. At that point, and your only recourse would be to take it to the Third Court of Appeals in Austin, Texas. And you think local lawyers are expensive? Wait till you try to hire an appellate lawyer. So
Okay.
anyway,
So
No, I understand.
there's going to be an excellent chance there will be a final order in this matter by the end of this month, sir.
May I ask a question? So it is not final though until after either this becomes final in 3 days, right? Or in 2 weeks after I go and see the other judge, correct? What is it, de novo? Correct?
Yes, sir.
And so so I would like to be clear because they've been calling my place of employment and wondering when my employer is going to pay the garnishments, even though I've informed my employer and everybody that I'm in dispute, right? And it's been
Okay, stop. Right now, sir, there's nothing before me dealing with any type of a garnishment of wages or anything like that. If the state has sent off administrative paperwork to your employer, they still have the right to do that. And that may just be the regular child support garnishment that you should have been paying all along through the court. So, but the bottom line is,
they
sir,
called.
the
Is what I
state
was
has
saying.
the state has the right to proceed on all aspects of your case that they can do administratively. If that's a totally different ball of wax, that's not before me. That's not before the district judge. That's left up to them. And I'm not going to tell you they're going to stop doing that, sir.
No, but my question is, Your Honor, it's in dispute, correct? Like, it's not that
No, sir,
it isn't in order as of right now, correct? That's why I'm here in court. It's a dispute.
Yes, sir. That part's in dispute, but that doesn't mean the state that's not going to start trying to keep to garnish or do anything else. Only the thing that's in dispute is what you've signed off on to being here today, sir, and got a copy of. That's it. Nothing else.
Which is the amount of child support, is what I'm saying. So how would they garnish if the child support is in dispute?
Mr. Werner, it's the amount of child support going forward, sir.
Yes, sir. I'm just asking. These
Okay,
are
it's
need to know
it's the
questions,
amount of
bro.
child support going forward. The amount of child support you owed on the first day of May, you still owe. Amount of child support you owe on the first day of April is locked in. You know that you owe that,
No,
and
I understand that,
so.
but it
All
is
right,
in dispute.
Mr. Werner, I got other cases to hear, and you've been given the right to de novo. I've done it on the record, and you have, like I said, you have 3 days to do it. And but I will let you know I plan on signing off on the non-agreed to child support review order and making that the order of the court. So it's up to you, sir, to do what you need to do.
10-4. Thank you, sir.
All right, thank you very much. And we're Ms. Warner, any other final questions, ma'am?
I guess I just want to make clear, he's still obligated with at
Oh,
least
yeah.
what.
Yeah, what he owed, the new, what date does the
That
new?
doesn't mean he's gonna pay, but it'll be, if anything, added to.
Yes, ma'am.
Okay.
Yes, ma'am. I
That's-
think the new order is started the first day of May. Is that correct, Mr. Gwen?
That is correct.
All right, here's the deal, sir, ma'am, that under the law, it's due on the first, but it's not late or becomes part of the unpaid child support until the last day of May. So it's due the first, but it's not. But the state at the district court sets that aside. That's set aside. But everything he owed up, everything that was supposed to be paid up to the 30th of April, he still owes. Okay.
Thank you.
So
All right.
what happens if I go quit my place of employment right now? I'm still responsible for that money, or do I need to put in another
Yes, sir,
modification?
you are, Mr. Werner, you said probably, I don't mean to laugh, sir, but you shouldn't tell the judge you're gonna do something like that, because if you
I'm
appear
asking.
before me, yeah, no, sir, you're asking me, and I'm not gonna give you that legal advice. Go ask somebody else. I'm not your lawyer. But you just said
All
it
right,
to
thank
me. So if you show up, if they file a motion to hold you contempt and bring you to the court, and they say, hey, Judge, this is the guy that was asking you what happens if he quits his job, and guess what he did? So
Well,
yeah.
I don't agree with the amount. It's an absurd amount of money, and I don't understand how we can get to that amount of money. You know, and I tried to come before a judge. I tried to plead my case here, and it's still an exorbitant amount of money, right? I can't afford
Yes,
it,
sir.
and I haven't paid child support, and my daughter isn't not in need of anything.
Mr. Werner, we're through. I got other hearings to hear.
Yes, sir.
I agree. We're off
Yes,
the
sir.
record. Bye.